Okay, so let's go ahead and get started. Here's where we are. Do all the regular admonitions and all that kind of stuff. And the good news today is that we're going to be rounding out the residential listing agreement, which means we're going to be finishing it off. And next week at this time, we'll be doing the new forms. And of course, at one point, Gov. Hutchinson promised me that he wouldn't change them anymore because I'd had to rewrite my presentation so many times that I was like, you know what, just let me know when you're done. As of this point, you're aware of the fact that we were supposedly updating the forms library on Monday. I'm not seeing that was done. I think they're still working on it. Of course, I could have the date wrong, but I doubt it. But anyway, so they are still working on getting that library updated. If you have templates in the library, much like we have listing agreement templates in our library, then you would be able, your templates would also be updated. They will not update a transaction that's in progress. So today we're going to talk about the listing agreement, and we're going to spend a little bit of time on it. And frankly, I had a great compliment from a very big broker who I have a tremendous amount of respect for. And she says, nobody understands the nuances of our forms the way that you do. And it's just interesting because, I've got so many different perspectives that I come from. One of them is from, the practical part of doing real estate. I do this every day, right? I mean, I've 41 years of this happiness and adjusting as it went along. And then from the legal perspective, teaching the law class and, the continuing ed for attorneys and things like that. Expert witness trial, all this stuff. I see all this stuff, and then I go, God, I just need to tell people about it. And so here we are, and thank you all for that. So I've already generated my first complaint. What is the difference between CAR forms and SDAR forms? That is, I know where the CR forms, but where are they? Okay, great. Okay, so Daniel, good question. All right, so we have, when you go to the CAR library, most people log into CAR, and then they click on Access Forms, and they get the forms. And over on the right-hand side of the forms, and I'm using my left hand because from the teacher perspective, it's the other side. But on the right-hand side, you see click the drop down, and you get all the forms. And within that, there is the SDAR library. If you're a member of the San Diego Association of Realtors, then you get the library for free. Certainly a benefit of membership. And because, there's everybody I know is trying to copy the stuff that we have in our library. And frankly, it wouldn't be that tough to copy, but you got to make it look like you didn't intend to copy it. Right, so even the CAR form SPQ, Seller Property Questionnaire, we created it at San Diego in our risk management committee. We created what we referred to as the seller's additional disclosures, and that was the SAD form. And so it was only available for members of SDAR. Well, CAR liked the form so much, and they had to see it because we had to give it to them to publish inside of zip forms. But they created their SPQ off of that. And then, of course, we came back and said, well, that's nice. You've now taken our form and created a statewide form, but there's a lot of stuff missing in the local area. So the standard of practice in the local area is the SPQA, Seller Property Questionnaire Addendum. So you need all three. You need the TDS, you need the SPQ, and you need the SPQA. And anyway, so the answer to the question is the SDAR Forms Library is called the Risk Management Library, put together by probably 26 of the brightest real estate attorneys that I know, and with input from a lot of brokers. So anyway, if you don't have access to it, circle back with me or contact membership@sdar.com, and they'll make sure that it's included in there. Okay. So Daniel, thank you. Nice, good question. All right. So that being said, here's the regular stuff. You all know, you all know me, right? I'm not an attorney. I don't give legal advice. I don't care. I'm not going to practice. I've got my law degree. I got the same degree they have, but I'm just not interested. It's like first of all, there's no money in it. And I think that attorneys work a heck of a lot harder than we do. So I'm just, I'm not going to give legal advice. I do a lot of trial work. I like going to court. I think it's fun, really. For me, it's kind of like a sandbox. I get to play in the sand, but it's usually defending real estate brokers. So, and that's usually in the capacity as an expert witness, not as an attorney. So attorneys hire me, and then I chat about the way our business operates in trial. I get to sit up with the judge and all that. It's really kind of cool. I get to work the jury. So anyway, that's all that stuff. So none of this is intended to be a substitute for the advice of your broker. Listen, please, you need to talk to your broker. You're paying your broker good money to be there, and your broker's there, tasked with supervising you and giving you guidance. So that's always a good resource is to talk to your broker, and then of course talk to your attorney. We did a really good class earlier this morning on counteroffers, multiple counteroffers and backup offers, and I thought the class went really, really well. If you want the webinar, let me know, and we'll go ahead and send it off to you. But that was fun. But we discussed a lot of the things that people put into counteroffers, and so there's again another member benefit of being here. I think SDAR just hasn't figured out yet how to monetize charging for these classes. But in the meantime, keep coming, right? Okay, it's free. It's a good price. So there's my email address. I'll pull it up again later to let you know, but it's not going to change between now and the end of our webinar today. So what are your thoughts about being a real more? Okay. Okay, so I'll cover that one off topic later. All right, so let's go ahead and I'm going to jump into a new share, and we're going to start talking about what we do for a living. Okay, so we're going to talk about, let me back up here, go back to the beginning of what we're doing. I did promise you that I would show you the new listing agreement. So, and I'll show that to you now, only because I think it's important for you to see it. And then of course, I got to remember where I put it. Okay, apparently I did not put it in there because that says the Zip Forms is out of business. Yeah, right. Screen resolved, and then a new screen share, and then, goodness gracious, what did I do with it? 12 years of college. Here it is. Okay, all right. So here is the new listing agreement. And I'm going to go ahead and scroll up to the top. There aren't a lot of incredible changes to this agreement. The majority of the changes are going to be in the section on rats. Where's the original version of it? Here it is right here. Okay, so this is the draft. So the final one is not in there yet, but you can see that the biggest changes were really subject matter we're going to cover today anyway. All they did was just realign some of the paragraphs. So, as we recycle, next week we'll do new forms. The week after that, we'll start in the buyer representation agreement. We'll do that for a couple of weeks, and then we'll start this all over again. So, it's job security for me, right? They keep changing this stuff, and God knows I'm on top of it. So there's a lot to discuss, but for yours and my purposes, if anybody wants this, send me an email. I will send you a copy of the draft. It's supposed to be in your Zip Forms. It was not in there when I checked this morning. So something's going on, but I'm not going to worry about it. Okay. Okay, not a bad problem to have, but if I listed a property a week ago, should I add an addendum including changes? And the answer to that is, the answer to that is that if you currently have a listing, we don't want to mess with what you're doing. So don't go changing, as we say. If you want to relist it, but remember, whatever that original listing period start to end was, if you put it in the multiple listing service, you're not going to be able to change that just because you put a new form in there. So I probably wouldn't, but you could use the new form. Just you're going to have all the same dates, all the same information. So, there is no addendum to doing it. Now, the way the way the form works, if you start a transaction after we ultimately publish it, and again, it's not in there yet, but after we ultimately publish it, if you start a transaction, you need to use the new form. And I can send you that too. I've got all the forms and everything all dialed up. And so again, send me an email and I'll send you the breakdown of the new forms and all that kind of stuff. So, good question, Daniel. But I always encourage people to use what you got at the time. Use all the weapons you have at your disposal, as we say, and don't go changing anything unless we do some kind of crazy stuff like when we introduced the new FERPTA back a couple of years ago, and the law took effect on January 1. So we literally told everybody, you need to use the new FERPTA. You don't want to use the old one because it's not in compliance anymore. And so that would be one of those situations. We have a couple of new forms. But for the most part, most of the forms that we have changed where you cannot use the old version, if you haven't used it yet, then put the new one in there. But if you have already used it and already had it signed by the parties, then you know what? I'm going to tell you, you can upgrade, not upgrade, talk to your broker. That's a good broker decision, a good broker question. As I said, on the listing agreement, the major items that changed was references to clear cooperation, and essentially what we used to have inside of a box. We've changed that. Again, we're going to have a whole presentation on this next week, but it had mostly to do with clear cooperation. That was the biggest substantive change in the listing agreement. Okay, so I wanted to at least make you aware of that. This is the old version. This is the version that is currently still in zip forms, so you can't change it. I mean, it's already in zip forms under the templates. And again, we won't change a transaction that you have in progress. So that being said, gosh, I hope you're able to see all those things. Yes, you are. Okay, good. So that being said, let's go back and let's talk about our subject matter for today. So we're going to talk about the entire agreement. So here's the deal. Remember now, we're talking about the residential listing agreement. This is the agreement between the broker, the seller's broker, and the seller. Okay, not the agents. The agents are signing on behalf of the broker, that kind of thing, but the listing belongs to the broker. So we want everybody to understand that, that this is going to constitute, and I get to do my little annotation here. Hang on a second, because I love my little annotation. So I'm going to do a little annotation. So this is going to be the entire agreement. Okay, so I always like to say this is the whole agreement, nothing but the agreement, so help me God, this is it. Okay, this is the entire agreement. So in other words, there's no sidebar, there's no I was crossing my fingers, all the cute little things that we used to do. This is everything right in here. And so we need to make it clear to the seller that if they have something that's important to them, or if you, the broker, have something that's important to you, this is where you need to be memorializing that, okay? I mean, otherwise, any modification, well, we're going to get to modifications and all that in just a second. So all prior discussions, negotiations, and agreements between the parties, that's between the seller and the seller's broker, concerning the subject matter of this agreement, so having to do with this, what kind of an agreement is it? It is an employment agreement. Remember that. Okay, are superseded by this agreement. So in other words, if you had any kind of understanding or, nudge, nudge, or wink, wink, or whatever, this is going to supersede all of that. So no matter what oral promises were made, it's really difficult. Remember, the statute of fraud says that an interest in land, in order to be enforceable, must be in writing, and so all of our employment agreements, our listing agreement, our buyer representation agreement, they have to be in writing. And oh, by the way, in order to enforce them, right? And oh, by the way, the DRE says, nah, not just so that you can enforce them, but we need to have you have that, or we're not going to let you collect a commission. So it's really important to us that we have the appropriate paperwork at the appropriate time. Okay. All right. So all of that other stuff, anything else you had going on is superseded by this agreement. Okay. Which constitutes the entire contract. This is everything right here. Okay. And a complete and exclusive expression of their agreement, and may not be contradicted by evidence of any prior agreement or contemporaneous oral agreement. Okay, so we have little things like for parole evidence rule, and we have all kinds of fancy little names for things that are going to that would try to get in the way of this. But this says this is it. This is the whole thing. Any other conversations you think you might have had aren't going to apply. It has to all be included in here if you wanted to include it against the agreement. Okay, so and a contemporaneous oral agreement just means that the agent says to the seller, oh, by the way, yeah, I know we're signing this form right now, but you and I know that you can cancel at any time. I hate that. Okay, if you're going to create a contract between the parties, then be gutsy enough to stand up to it and say, this is going to be an agreement between us. Now, I don't use the word contract until somebody's trying to get out of something, but I use the word agreement. And so, this is our agreement. And so, but don't worry about it. I'll take care of it. Or the broker listens to me. I've heard all this, right? And it just makes me insane, because essentially you're creating an illusory contract. You're creating a contract that's incapable of enforcement from the beginning. And so, we don't want to do that. Remember, we love our broker. We want to take good care of our broker. So let's make sure we do things the right way the first time. Okay. All right. Good. I haven't upset anybody yet. Okay. All right. So let's go forward here just a little bit. If And this is going to be called the law of severalty. Okay, so law of severalty says if any provision of this agreement is held to be ineffective or invalid. Okay, so in other words, remember what I said to you the very first time we ever started listening to each other when we were doing classes. Notice that all the paragraphs are numbered. Okay, and the reason that the paragraphs are numbered is, well, one, because lawyers think in terms of outlines, right? I mean, they're just, that's structure. It's like brainwashing. You know, they learn a whole new way of thinking. Everything is, you know, paragraph number one. I mean, you call me up and you say, you know, where's that provision that talks about prorations, you know, in the purchase agreement? And I go, paragraph number 18, you know, I got it. Okay, I got it down. All right, but that's how we think. Okay, and so lawyers think that way. They want to have everything in an outline form. It just makes sense. And so, but then along comes this little rule that says that if any one paragraph is held to be invalid or ineffective, then the remaining provisions will nevertheless be given full force and effect. And full force and effect is kind of one of those cool little things you learned as you were studying to get your real estate license. But at the end of the day, it says, you know what, it's still going to be binding on the parties. So if paragraph number 21 fails, if something happens that destroys paragraph number 21, the rest of the contract still prevails. All right, and that's an attempt to avoid, you know, the picky little thing. You know, you got this one little thing that, you know, the pre-printed language, you know, doesn't survive, you know, constitutional muster, and then, you know, of course the client wants to destroy the entire thing. It's like, nah, we're gonna make it so, yeah, okay, you can destroy that, but if you want the other stuff to be destroyed, you have to destroy that too. So anyway, that's my law of severalty. Okay, so, you know, just because one paragraph goes away, and remember they're numbered, just because one paragraph goes away doesn't mean that the rest of it goes away. You know, you're going to have to go after this as well. Okay, everybody good with that? All right, then this agreement, okay, and any supplement, addendum, modification, including any photocopy or facsimile. You all know what facsimiles are? Do you know what a photocopy is? You know, Linda was telling me this the other day. She said, you know what, I don't think anybody knows what microfiche is. So anyway, anybody know what a punch card looks like? So this is where, you know, I came from, was from, you know, I actually created programs that we you know, back in the 70s, early 70s. And the computer I used to work on is now on the Smithsonian Institution in over by Dulles Airport, which is just crazy as hell. So anyway, so photocopy or facsimile may be executed in counterparts. And so what is a counterpart? A counterpart says that as long as the two documents are identical, that the parties don't need to sign on each on the same piece of identical paper. They can sign different copies of it, and that's called counterpart or counter signatures. Okay, so we have this thing in law in law school that we call the light test. The light test is I can hold up one document that's got, you know, Mr. Seller's signature on it, and then I can hold up the other document that has Mrs. Seller's signature on it, and I can hold up another document that has the broker's signature on it. If all three documents are identical, no changes to it, all three are identical, then it's a complete agreement. That's a counter signature on all three, and that's an agreement between the parties. Okay, now you and I, you know, we're a little OCD. We like to get it all on the same piece of paper, but you know what? I say paper, but you don't do paper, right? Everything we do is electronic. Okay, all right. So is everybody good with that? Counterparts are really cool, and we call that the light test versus the laugh test. And the laugh test is that one that says that, you know, the judge is holding up the document that you're asking to enforce against the client, and the judge is looking at it. He starts laughing uncontrollably, and it's like that fourth generation fax page, and starts laughing uncontrollably. We call that the laugh test. When you fail the laugh test, your case isn't looking good. Okay, so a couple little things, you know, just to keep you interested. All right. Okay, that being said, that's paragraph number 20. Okay, pretty easy. Got through it. No harm, no foul. Nobody was injured. Let's talk about paragraph number 21. Okay, 21, we're going to talk about ownership, title, and authority. Okay, so ownership of property. So we want to make sure that the person that we are signing the listing agreement with is the legal owner of the property or has the authority to sign on behalf of the owner of the property. Because remember, there's this it flows downhill thing that says that as we're putting this listing agreement together, once we got the listing agreement, and then we go and we put it in the multiple listing service, and in the multiple listing service, we have issued a unconditional offer of compensation. And so if we mess it up at this point, then somebody brings us an offer and we messed this up, then that means that we're probably going to have to pay a commission to that other agent if we can't bind the seller to this agreement. All right. So seller has to have authority. They have to have ownership interest, and irrespective of anybody else's interest in the property. So let's take a look at that. I want to dig into that a little bit. So the seller warns that one, seller is the owner of the property. Sounds pretty simple, right? But we didn't have that language in there before. So pretty much we said the seller's sitting there signing away. Nobody bothered to ask the question, do you own the place, right? Okay, so now we have that question in there. And so now the seller signing this document is saying, hey, I own the place, okay? It's mine, all right? And then that way we don't have this little challenge later on, you know, when I said, well, you didn't ask me if I own the place. Well, now we've asked you, and now you're signing a document that says that you are, okay? I know the question you're gonna ask me, and I think it might already be in there, and that is, do you need to get proof that they're the owner? And so let's talk about that. Let me see what the question is. Always be sure, oh, thank you, Daniel. Always be sure to check with the title company to see how the home ownership is represented. Bingo. Okay, so now you can look at CRS tax data, and we always do, to see who the seller of the property is. All right, so even zip forms, when you put in MLS Connect, it does not bring in the seller's information. And part of the reason behind that is because it's too much for them to figure out. I mean, think about it for a second. You know, the seller says, you know, I hold the property in trust, and you have them sign as an individual. You know, you might not have a listing agreement. Okay, in fact, I know you don't. And that has happened. I've been involved in lawsuits where the seller said, no, agent, no, I signed the agreement. In fact, I had one where the buyer sues the owner of the property, who happens to be an attorney, and sues him personally, but the property was held in trust. So the buyer did the lawsuit wrong, and then gets, you know, the attorney gets in front of the judge in small claims court. And, you know, you can't, you know, people think that you can't take an attorney to small claims court. Well, if you're the owner of the property and you just happen to be an attorney, yeah, you can go to small claims court. So, you know, here's the attorney saying to the judge, I'm sorry, Your Honor, they sued me personally. They didn't sue me in the trust. And it was a stall, and the judge knew it. And the judge told the buyer to go back and refile their lawsuit. It was a delay. You know, ultimately the seller attorney lost that case and was forced to pay damages. But, you know, at the end of the day, it just, you know, these poor people, it was everything they had. I mean, I felt terrible. I mean, their deposit that they had put against this property, and this guy just held on to it, and, you know, knowing that it was reckless, knowing that the buyer couldn't buy the property. And so, you know, it just wasn't fair. But sometimes, you know, you got bad people in every industry, just the way it is. Okay, so Daniel, your comment about checking with title. So you can check with title. Linda pulls the grant deed from the county records. So she literally looks up, how is title held? She doesn't quite trust the CRS tax data because it's rarely ever thorough, but she goes and gets the grant deed to look at it to see exactly how they appear on title. And that's exactly what the document does. When we create the listing agreement, it is with the current owner for real of the property. And we know we can enforce that later. You know, we have a whole bank of attorneys that would love to have that case. Okay. All right. Okay. That being said, hi, Kevin, would you handle listing agreements with more than 2 sellers on title, since there's only 2 available sections on title? Okay. So more than 2 sellers on title. And the answer is yes. We're going to talk about that in a couple minutes. We're going to talk about that additional signature addendum. Okay. All right. Thank you. Anonymous. I know who you are, but it's funny that your thing says anonymous attendee. So, okay, so back to my form. So number 1 was that, yeah, I represent that I am the owner of the property. Number 2 says no other persons or entities have title to the property. Okay, so in other words, I haven't quit claimed it to anybody. I haven't shared title with someone that I'm not telling you about. Okay, and then number 3 says, what is going on with my marker? Gosh darn it. Oh, you know what? I think it is. I think the battery might be low. Number 3 is seller has the authority to both execute this agreement and sell the property. So this person who is signing, claiming to be the seller, claiming to be the owner, claiming that there are no other entities that have an ownership interest, has the authority. So like, for example, I own property in trust, and the trust happens to have my name in it. And some of my trusts do have my name in it. And so, you know, but the trust might have been created to protect me from me. And so literally there may be somebody else who is the signatory for that trust. So we call that the trust cert, or we call it the what's the other thing? The paperwork that's required, you know, the statutory agent for the corporation, for things like that. Okay, so but the trust, it might have my name in it, but I might not be, you know, qualified to sign on my behalf. And I can tell you, I've represented some very large companies where, you know, the individual who I'm working with is going to make billions of dollars, but it is only doled out $10,000 a month because, you know, we all know that, you know, kids just, you know, they don't have any kind of, you know, concept of, you know, what money looks like. And so, you know, 10,000 a month. Can you imagine somebody having difficulty living off of 10,000 a month and having to actually go get a job? So, you know, maybe that's most of us, right? Because we're all making 30 or 40,000 a month. So that's good. Okay, so those three things have to apply. And then we have exceptions to ownership, title, and authority are as follows. This is a good time. This is why I like you being in front of the seller when you're going over this, but this is a good time to discuss who else has ownership, title, and authority on this property. Tell me now, okay? Because if you don't tell me now, then we might have an issue later. If the buyer's agent comes after me for a commission, then my broker's probably going to come after the seller and bring them in under a theory of law called joinder. We'll just bring them in, okay? All right. It's nice to be able to see my other computer and what I look like when I'm drinking my tea. Okay, it's my afternoon tea. Okay, all right, everybody good? Questions about any of that? Okay, I guess that's it for that. Okay, so good. So let's go back. I'm going to clear the screen and let's go ahead and go on with the next part of things. So again, this is my entire agreement. This is the seller representing that they have title to the property and that nobody else is going to come in and lay claim to that. Okay, so let's go ahead and click on the second part. So now we're going to talk about some really fun stuff. We're going to talk about representative capacity. And I have this conversation. I don't know why it's so confusing for people, but you know, I even had one broker, pretty good sized brokerage, ask me about why I did it the way I did it. And I explained it to them, but in the course of explaining it to them, I realized, you know, I want to make sure I'm giving good advice, right? I mean, the broker's not asking me for legal advice. The broker's asking me why I'm doing it in a transaction with one of his agents, and so his or her agents. And so, you know, I sat there afterward doubting myself, and which was pretty comical because then I get a hold of Car Legal, like, you know, I got the direct line, right? I got a direct line to Car Legal, and so the guy goes, "No, you're right." So that's what it was intended to do. You know, you're okay. I said, God, I was sitting there, I'm doubting myself, and I just don't doubt myself. But this is one of those situations where I had to ask myself, am I sure I got that right? So remember, if you ever have a problem with stuff like that, you can always give me a holler. I am so happy to help you. I really am. You're not a bother. The thing that bothers me more about stuff is people will send me an email and then I won't respond, right? Because it takes me a lot of times 24 hours to get back to an email sometimes. And, you know, like I just did a webinar an hour and a half ago that, you know, I had 30 requests for my forms. And so, you know, I'm literally forwarding them on SDAR. God love them, is taking on the task of forwarding those, you know, all the file. I've already shared the file with them, so they just give them everything. And that's good. But, you know, sometimes I forget. And so it hurts my feelings when somebody says, well, you didn't respond to me 3 months ago. And I'm like, why did you get back? You're not bothering me. You know, get a hold of me again. Hit me again. Dottie, I still owe you a phone call. And, you know, after I'm done with this webinar, I'm going to talk. I'll give you a holler. Okay. But you know, what you have to say is important. It really is, because here you are out practicing real estate. And again, as I said earlier, you know, if you look good, you make me look good. So I'd like you to look good. Okay. All right. Okay, so let's talk about my RCSD. Let's talk about my representative capacity, and we're just going to nail this, okay? So this is one of my favorite things. So RCSD. So by checking the box, boy, that is weird. So by checking the box, we are saying that the seller of this property is a non-natural person. So remember, we only have two different types of people for purposes of contract. We have a natural person, you know, bleed. Okay, and then we have a non-natural person, which is everybody else, all of the other stuff. So I can be somebody, I can be a sole proprietor. Okay, that's a non-natural person if I'm signing on behalf of the entity. Okay, I can be signing for power of attorney for someone. I can be signing as a statutory agent for a corporation. I can be signing as the designated officer for a trust, whatever. I got a lot of capacities that I can sign something other than a natural person. And so we're going to look at this language now. And then I think I might change a couple of ways of thinking here as we're going, because I see people that they kind of get confused at this when they're working on it. So we're going to nail it. Okay, that's what we're going to do. This listing agreement, I sure don't need a keyboard. Okay, so this listing agreement is being signed by the seller, for the seller, by an individual acting in a representative capacity. Now, some of you will remember this form's only about 5 or 6 years old, okay? So in other words, we had to create a form, you know, because people were doing comma TTEE, comma trustee. They're coming up with all kinds of variations on a theme. We just wanted to make it easy on everybody and say, okay, where I sign things with my name, I am signing on behalf of this other entity. So I'm going to go through this paragraph and then we're going to go look at the form, okay? So by an individual action in a representative capacity as specified in the attached representative capacity signature disclosure. And in this case, it is my RCSDS. There are no changes to that form in this publish, in the June publish. There is a change to the buyer. So the RCSDB, the representative capacity signature disclosure for the buyer, there is a change in it. And I would recommend that you take a look at the form. And again, send me an email and I'll send you all that stuff, okay? Okay, all right. That being said, so anywhere that I sign, this document says that I am signing wherever the signature or initials of the representative identified in the RCSD appear on this agreement or any related documents, it shall be deemed to be in a representative capacity for the entity described and not in an individual capacity. Okay, so I am signing on behalf of someone else, or I'm signing on behalf of another entity, but I'm the natural person signing for it. Now, it begs the question, I hope you don't do this, but remember, you would never want to be the representative, right? Okay, because there's seriously, it could be a serious conflict of interest, could create some real problems for you, just like you would never hold power of attorney for your client and sign on your client's behalf when you stand to gain a commission out of it. There are going to be some challenges to that, and I mean legal challenges and some other things. So anyway, we're going to be signing it as a representative for the entity and not in an individual capacity unless we've indicated otherwise, okay? So the finesse part about this is filling out the form properly. That's the fun part. Seller, number one, represents that the entity for which the individual is signing already exists. Now, folks, and there should be a comma there. Now listen, how many times have you had somebody tell you, you know, that we're in the middle of the process of forming the corporation, or we're in the process of creating the partnership. We don't have it all done yet, but we want to buy it in the partnership, so we want to sign it in the partnership. Fails the question, okay? Because here's the deal. If the entity does not exist, then please don't sign on behalf of something that doesn't exist. It's kind of like your buyer saying to you, here's my earnest money check for $20,000, but just to let you know, there's no money in the account. And you go, well, when will the money be in the account? And they say, well, I'm going to win it this weekend up in Las Vegas. Okay, probably wouldn't take that check. Okay, first of all, I wouldn't take a check anyway. It needs to be between the buyer and the seller. But you know, at the same time, you winning the money this weekend is probably not a good representation of your business profession. And especially, folks, if you know, then you definitely don't want to be a co-conspirator of that discussion, okay? So, all right, so number one, that the entity exists. Number two, shall deliver to the broker, because remember, this is the listing agreement. The only person who's going to see this stuff is going to be you, the broker, or you, the agent for the broker, and the seller, okay, shall deliver to the broker within 3 days after execution. So after 3 days after signing all of this stuff, okay, I need evidence of authority to act, such as, but not limited to, it could be any of these things, okay? And again, this is an or statement, and I had someone ask me this question the other day because they had asked for documentation, from the opposing side. So they were the buyer's agent, I guess, and the seller, was signing on behalf of an entity. And of course, it ended up being a seller's escrow company. And then now they're trying to get the seller to give them a copy of a document that authorizes them to sign on behalf of the entity. and they were getting pushback on that. And then I think, frankly, I think that the escrow company gave some really bad legal advice, and it was legal advice. Okay, so I'm not saying that it was a good legal advice. I'm just saying the way they phrased it, it's legal advice. Okay, so I wouldn't do that. All right. So anyway, so this is an or statement. Give me something that says, Mr. and Mrs. Seller, who better to ask for that than the listing broker, right? Something that says that you have authority to act in that capacity. Okay, because otherwise I have a listing agreement with lawn furniture. I have nothing. Okay, I need to have something that I know is enforceable, because remember what I said earlier, there's that trickle down the line kind of thing that says if I get an offer on this thing, and like for example, you've got a husband and wife on title. Only the husband's at the listing appointment, and then the husband says, don't worry about it, I have authorization from my wife to sign on her behalf. I've had this happen. I wasn't at that appointment. I was at the other appointment with the buyer. The buyer writes the offer on the property. It's in the MLS, and boom, we go together on contract on this thing, and then only to find out that the seller, Mr. Seller, does not have authority from the wife. In fact, the wife did not know that she was about to go through a marital restructuring, and essentially the husband was trying to sell it without her. She's on title. Okay, so anyway, losing argument, and oh, by the way, the broker was really quick. It cost, I think, them about 10 grand to get Mrs. Seller to sign the listing agreement, because Mrs. Seller wasn't interested in selling the property, but it cost them 10 grand to make her interested. Okay, if you know what I'm talking about. Okay, everybody good with that? Let me see, other questions? Nope, we're good so far. Okay, good. All right, so. All right, so what I want to do, well, let me finish this. Okay, so here are, remember when we see such as but not limited to, we know the lawyers wrote that. I love it when lawyers write things. It's great to read, okay? So applicable trust document, portion thereof, just give me the cert. I don't need to see the entire trust. I just need to see the document. It's a 1 or a 2-page document that says you have authority to sign on behalf of the trust. Letters testamentary, something from the court, a court order. That's good news. A power of attorney. Okay, these are things I might, that I might have to share later. So don't give me all the family jewels. All right, resolution, formation documents of the business entity. Just give me something that says you're authorized to sign. And so I've had many a time where our agents will come in and they'll go, I got all this stuff signed. And I look at it and go, that's a trust. And they go, yeah. And I go, well, where's it? Just give me something that says that this person's authorized to sign on behalf of the trust. Come to find out that, it's harder than you think. They can't find it, whatever. They're going to have to produce it at some point, so that to convince title, they might as well convince me before I put it in the multiple listing service, because otherwise I may have a listing agreement signed by someone who doesn't have the capacity to contract. Okay. All right. Everybody good with that? Okay. Now what I want to do is I want to pull up that document for you so that you can see what it looks like. So let's take a look at the, he says with confidence, here we go. I want to take a look at my representative capacity signature disclosure. And here it is. So I'm going to move this up out of the way a little bit. And I'm going to increase the size of that a little bit. Okay. Now here's my document. This is the representative capacity signature disclosure for seller representatives. Now in our template, we automatically have this form included in the template, because you know what? You're just going to find probably half of our properties in San Diego County are held by non-natural persons. So, people just don't buy property in their own name anymore. I know I haven't done it for decades. Okay. I buy them in other names, so that I'm a little difficult to find, that kind of thing. So just so you know, we have this in our template because we're just assuming we're probably going to need to use it in the transaction. Okay. So again, this is the RCSDS. And let me show you that. Here is my RCSDS, and it was just recently updated June of last year. This form is not an assignment. Get that out of your head. So we do have another form called an assignment of agreement addendum. That's what you would do to do an assignment. Okay, this is not that form, all right? And it should not be used to add parties after the contract has been formed. So you need to do your homework at the time you take the listing, okay? All right, so the purpose of the form is identify who the principal is and who has authority to sign documents on behalf of the principal. Okay, all right. This is a disclosure to one or more of the following: either the listing agreement, the purchase agreement, some other agreement specified below in which the seller is identified. If a trust, identify seller as the trustee of the trust, or by simplified trust name. And it'll be a very official looking thing. You can't miss it. If you had it on your computer, you do copy paste. Okay. So for example, John Doe co-trustee, Jane Doe co-trustee, revocable family trust, family name of the trust should be identified in 1A below, and we're going to talk about that. If power of attorney, insert the principal's name as the seller. Okay. All right. So let's take a look. Let's go ahead and let's clear this out and let's take a look at my paragraphs. All right. So starting off at the top, I've got, this is it. This is the big part of it all right here. Okay. This is the part that gets us the most confused, and yet it's, I think, the easiest part. So it's either going to be, it can't be all of these things, right? It's either going to be a trust. And so now I'm going to take and I'm going to copy the name of the trust, because that's, if the property is held in trust, then I can probably copy it off the trust document and put the full name of the trust in here. Okay. And so, that includes the date. So, most trusts, like I have a Kevin M. Burke trust dated X something or other. It's about 20 years old, and my property goes in and out of it, stuff like that. But I need the full name of the legal entity that owns the property. Okay. If it is, and the person signing below is or are sole co-trustees, whatever. Number 2, entity. So what are my entities? Well, those are pretty, most of these, right? It's either going to be a corporation, or it's going to be an LLC, which is a limited liability company, or it's going to be a partnership, or if you go some other strange thing, you're going to put that in there. Okay. So who is which is authorized, the officers, managing members, whatever. I have one right now. We got a managing member, partner, person signing below, to act on its behalf, authorizing resolution of the applicable body of the entity described above is or is not attached. And so please check the box. You either have it or you don't. Okay. And so this is at the time of the listing. Okay. So either you have it or you don't. Then I have my power of attorney, otherwise known as a POA, right? Okay. So that the person signing below has power of attorney. This is not a power of attorney document. This is just a document that references the fact that this person is signing on behalf of that power of attorney that they have. You should probably have a copy of that in your file. Okay. Here's my POA to act on their behalf. To a general power of attorney. If you are doing a real estate related matter, then the title company, in order to do all this, is going to require a specific power of attorney. Okay. And then what is the date? You've got to put the date in there. And then here's the admonition. This form is not a power of attorney. Power of attorney must have already been executed before this form can be used. Don't be signing on behalf of something that doesn't exist. Okay, everybody, I hope you're good with that. So you know what? If it doesn't exist, it doesn't exist. And tell the people, how are you holding title of the property right now? That's how you're going to be signing. Okay, all right. And if they're having trouble proving it, then there might be something else going on. Okay, and then finally, paragraph number D, it's an estate. So it's either an estate, a conservatorship, a guardianship, but you're going to know it's a very official document. Superior Court case, the name of the Superior Court case, the case number. Okay, those things are things that you're going to be looking for if you get those. The most likely entity that you're going to get is going to be number A, okay? And if I had to go through things, number 2, this is going to be number 2, that's going to be number 3, that's going to be number 4. It happens to be in the order in which they are in your document. And like I said, probably half of our properties in San Diego County are currently held in trust. My properties are in trust. Okay, a lot of people I know have their properties in trust, and a lot of the transactions that we do, there is a trust. And so then we're going to use the trust advisory form. Okay, all right. Okay, very good. And then finally down here towards the bottom, seller's representative represents that the trust entity or power of attorney already exists. How many times we got to say that? It's going to be really hard for somebody to come back later on. Well, I didn't know it had to be, it had to be currently in operation. And the answer is yes, it has to be currently in operation. Okay, so that's my RCSD. Now, how do I sign the RCSD? And this is the part, like I said before, this is the part that gets confusing, but let's demystify it. Okay, so here we go. Who's the seller? So the sign, the name of the trustee, officer, managing member, partner. So the name of that person. So in this case, what is the name of the person? It's Bob, right? Okay, so Bob, all right, is the representative. Bob signs it. What's Bob's title? Managing member, whatever. And then then you're going to make sure that you date it. Obviously you put the date next to it, whoever the seller is. You've got room for 2 of these. So I'm sorry, I shouldn't have done it quite that way. Up here it's going to say Bob. And then this is going to be, the person signing for it. And then so this is number 1. This is number 2. Everybody good with that? Okay. So we just need to know who the parties are. It's rare that you're going to have more, but if you have more, so Jane, is it Jane? Who was it that asked the question? We're going to go into what happens if I have more people that need to sign things. Okay. All right. So let's take a look as it goes further down the line. Acknowledgement of receipt by the other party. So in this case, when we take the listing, so the seller's broker, this in our case, so in our case, this would say, Burke Real Estate Consultants here, parties to a listing agreement dated, whatever today is for property known as legal description, property address, and then here's the name of the broker again, and then here is my signature. Okay, so that's what that part's going to look like at the time of the listing. All right, and I may very well have to be able to prove that I've got this, because guess what? At the time of the sale, all right, now at the time of the sale, this is where everybody's like, well, why didn't you do your homework at the time you took the listing? Okay, so here we are at the time of the sale, and at that point, the buyer is going to have their name in here. Here's the date of that agreement, the purchase agreement, and then the buyer signs that they have seen everything above, that they're cool with it. They understand that this is the person signing on behalf of the entity that purportedly owns the property. Everybody okay with that? And then if there's another agreement at the time of another agreement, if in fact there is another agreement. Okay. All right. Let me get my mouse back. Let me scroll down a little bit. Any questions on any of that? Seeing none, all those in favor, we'll go ahead and go on to the next one. Okay, so let's take a look now. I want to go back to, gosh, if I'm not on the form, I'm going to go crazy. Okay, so let's go back to our signature page. Here it is. So this is the part where we were just doing ownership and title. This is the part here that says, what happened there? I did it backwards again. Okay, representative capacity, and so it's being signed by the seller, et cetera, et cetera, et cetera, all that. Now what's happening? All right, now my program is having a meltdown. Okay, so this was my other agreement, and JPEG. Here we go. Okay, so by signing below, the seller acknowledges the seller has read, understands, and received a copy and agrees to the terms of the agreement. So in other words, you agree to be bound by our agreement. Seller signs their name, and if they are signing on behalf of the Bob Trust, they would sign their name, Ann, okay? But remember, I had that RCSD that says every time I sign my name, Ann, I'm signing on behalf of my signatory status with Bob's Trust. So here I'm going to sign Ann. Now, by the way, in the line here, the pre-printed language is going to have the Bob Trust, right? Because you need to have a contract with the entity that owns the property. And so on page 1 of my RLA, when it says seller's name, it needs to say the trust, not Ann. Okay, Ann is just the authorized signatory for the trust. So we want to make sure that the name of the trust is here. And if you did it right, you put it up in the page 1 of the RLA, it'll say the name of the trust. It'll say that where it says seller, it'll say the name of the entity. And then Ann later on signs the representative signature, capacity signature disclosure that says, I, Ann, am authorized to sign on behalf of the Bob Trust. Okay, so everywhere you see me sign Ann, which is what's going to happen, when they sign it, it's going to say Bob Trust, but then it's going to say Ann is signing it. That's what it's going to say. Okay, all right, everybody good? Okay, I do this every day. Every day. Today I think I did it 3. We sold 3 houses last night, and it's like every day I'm looking at these details. Okay, so that's for seller number 1. So we have number 1, we have seller number 2. So then to answer, whose question was it? Jane's? Okay, now I'm going to be wondering whose question it was. It was, who was it asked the question? That was including changes, textile company. I'm sorry, Anonymous. Okay, I'm playing with you. So Anonymous says, what happens if I've got a third person? And that's when I'm going to check this box right here that we're going to use CAR form ASA, which is my additional signature addendum. Now, this form shouldn't be that confusing. I'm going to tell you, I have been involved in court cases where I don't know what they were thinking when they used that form. I mean, it's not, it wasn't intended to add a party to a transaction that was already in progress, but I've seen TCs use it. I'm like, where'd you get that from? Well, what possessed you to do that? I hope the broker didn't tell you to do that because it wasn't done right. Okay, so let's take a look at my additional signature addendum. So again, this form is not an assignment. That's my AOAA, right? Should not be used to add new parties after a contract has been formed. Okay, all right, question. Hi, Nancy. There are two trustees that will be signing. Do you put the name of the trust in twice so it appears on each signature line? Nancy, that's a good question. You can. So remember that if I have it depends on whether or not it's an and trust, and I know this is a rhetorical question. I know you know the answer. But if it's an and trust that they both need to sign, yeah, I'll put them in twice. And then in zip forms, I'll put the email address for each individual, first email address for the first one, second email address for the second one. So that's when it's an and trust and it requires both. If it's an or trust and I only need one of them, then I'm only going to put it in one time. But the answer is, yeah, I'll put in the name of the trust twice if I've got an and trust, okay? A-N-D and trust, okay? Great question, okay? All right, the following are additional signatories too, and then we have my RPA, we have my RLA, we have whatever else you got going on. Again, what is all this? We know this to be the recitals. This is the linking part of the document that links it to the transaction, links it to the paperwork that we are in fact doing. Okay, so here's my admonition. Now we've got by signing below, the undersigned acknowledges receipt, of course. Okay, because we want them to be we want to be able to hold them to what they're signing, and if they don't have a copy of it, we're gonna have a hard time with that. Okay, and except to specify below, agree to all the terms and conditions, et cetera, et cetera, et cetera. Now I'm gonna hit you with a little zinger here. So Nancy, I know your next question. So here's the thing. So if I do have a third or a fourth party then that are also signatories of as the seller, and they're all required, I'm going to also tag them on zip forms. I'm going to tag their signatures as other parties, and I'm going to tag them next to everywhere that the seller has signed. I want them to sign as well, and I want them to initial as well. So just because of the fact that it doesn't have their name printed on the contract, because as Anonymous said a second ago, there's only room for two, and so I'm not going to let that stop me. I want to create a binding agreement with everybody, all the people that are going to be signatories. So page one, of the RLA, I'm going to have 4 sets of initials. Page 2, 4 sets of initials. When I get to the signature page, I'm going to have 4 sets of signatures, and then I'm going to have them sign here too. Okay, just because their name doesn't appear on the form doesn't mean that I'm not going to put them on the form. Okay, somewhere at or near underneath the language that we intend to bind them with. Now, some people will say, and I think I've had one attorney say that might be a little overkill. You know what? I'm guilty. Okay, I'll be overkill. I'll do that, and nobody's wiggling out of this. All right, so that's going to be important. So now we've named the parties, and here we're going to, one's going to be the buyer. So if that's a buyer, then my 4th buyer's down here, my 5th buyer's down here, okay? And then what are we gonna do? We're gonna print their name, and they're gonna sign it. They're gonna sign it down here, but they could be, as you suggested, maybe 4 different trusts own the property. I haven't seen that, but I guess it's possible, okay? And then I need their title. Whatever their title is, and then of course I want everybody to date it. So I'm going to have them sign this just because I want to be able to hold this one up to the listing agreement and say, yep, you're the owner too, but I'm also going to have you sign everywhere that the other signed. I'm just going to do that, okay? All right. Same thing holds true, by the way. If I'm using this form on the purchase agreement, well, I'm reading ahead. So let's take a look at that. So only initial the following if the document identified above contains an arbitration or liquidated damages provision. So remember that separate provision that needs an initial in order to be effective. And so now if they are going to if the contract between the buyer and the seller says that liquidated damages will apply, then I'm going to have the other two sellers initial it, but I'm also going to have these 2 initial it, and then guess what? I'm going to have them initial it again. Okay, so yeah, I know I'm beating the horse, but at the end of the day, nobody gets out of my deal. Okay, and that's just the way it is. I want everybody to understand this is about as good as it's going to get. It's going to get pretty ironclad. Okay, you're going to need to hire a really good attorney. Okay, so that's buyer. So I lost my stuff. Here's buyer number one. Here's buyer number two. Same rule applies. And remember, if one misses it and it requires a separate initial, then it's going to take a counter offer in order to fix it. Okay. All right. Robinson. Hi, Kevin. Would you suggest having an ASA filled out, listing the other CAR forms like TDS, SPQ? I don't think that's necessary, but that's a good question, Robinson. That's a good question. So here's the thing. As I said earlier, I'm going to have them sign it anyway. So if my TDS, which, you're right, we were supposed to fix this decades ago because, we were so married to forms first and then internet. So we would take the form and we try to jam it up into the internet and make it work. But what we were supposed to be doing, and I kind of hoped Lone Wolf would do it, and I don't see them doing it, and that is get it out of paper and get it up into the internet. So up in the internet, as you're typing the name, if it's, going to fill the line and go over, then it should, squeeze the letters together, right? Like a word wrap kind of thing. So those are the kinds of things I'm looking for. I'm looking for something that makes more sense on a phone or on the internet, so that it adjusts for me rather than I'm stuck with 16 characters, which is what we currently have. So in zip forms, if I hover over this field, it's going to tell me the name of the field. It's going to tell me how many characters I have available. And we should have gotten rid of that a long time ago. Okay, that should have been gone a long time ago. And I hope they watch this video. So, okay, so to answer your question, yeah, I'm going to have them sign everywhere. Listen, there's plenty of room for me to put 4 sets of signatures and 4 sets of initials on everything. It doesn't matter that their name doesn't appear. Their name appears here. So I'm going to get their name here. And then I'm also going to bind them by having them do all those other documents. Okay, does that help? Make sense? Okay, but the key ingredient here is to remember that if there's a separate paragraph that requires an initial in order to be effective, then and it's not initialed, then the paragraph, according to the contract, according to the and according to the counteroffer, says then the provision doesn't apply. So if you miss a liquidated damage, that's why it's so important. And Nancy, if somebody misses an initial on liquidated damages, you got to go back and fix it. You can't let it fly, because if it didn't get initialed, then it doesn't apply. And so we can't do that, okay? We need to make sure that everybody is bound by the same agreement. We need to make sure that we have a meeting of the minds, and basically this, that everybody says the same thing. The cover sheet, there needs to be an option to put the name of the trust in and the name of the representatives. Great question. So what I do, if we're talking about the seller as the trust, I put the name of the trust, as seller number 1, or the name of the buyer as a trust is buyer number 1. And then I'd use the RCSD to say, here's Ann going to sign on behalf of the trust. So, but I agree with you. We might, since we see so many of these, that maybe we need to have a thing that says this person signing, why can't we put the RCSD information in the cover sheet, page 1, right? Why not? Okay. All right. Okay. So I think that's everything I wanted to cover on the additional signature addendum. Yes, it is. Let's take a look. Let's go back to our form now. And I cannot believe how fast time goes by. I mean, seriously, it just flies. Okay, so let's take a look. We looked at our additional signature addendum. Let's take a look now. Where is my other form? Oh, it went backwards on me. Sorry. Okay, so here at the bottom of the seller's signature is the broker's signature. So let's take a look and see what that looks like. And then we'll have a couple things we'll need to discuss on that. So the broker firm name. So in my case, it's Breck, right? That's my firm name. Okay, license number for the broker. Okay. And then, yeah, you need to put your address in there. You need to put the city, state, zip. Please be thorough. Okay. You need to sign it, whether you are signing it on behalf of the broker, which you're the agent for the broker. Okay. And Nancy, in your case, you are the broker, so you would sign it. Here is your DRE number. And depending on how you hold your business. So for example, we're a corporation, Burke Real Estate Consultants, Inc. So as a result of that, we have a different corporate number than we do our broker number. So my broker number is 010000175, but our corporate DRE number is 01995787. So 2 completely different numbers. Obviously mine was given, at the time they first developed print. So it was a little while ago. And Nancy, I think your number is about as close to mine, right? You and I have been together for a long time. Okay, so down here now, I get into what happens. So anonymous, here's What happens if I have two brokers with different companies co-listing the property? Now, I'm going to tell you, before you do that, make sure you check with your broker, make sure it's okay with your broker. Don't go, you're not going to, remember you've got, 72 hours by DRE regulation to get everything in front of your broker. And if you miss the time period, your broker is stuck with something, you're going to be in trouble. So you want to make sure you pass it by your broker first. Do we co-list properties? I can tell you that we frown on it as an industry. We frown on it, but we created the form because we had people that were doing it. You got two real, high fancy, brokers out there that tough agents that are out there, and they just can't convince the seller to list with one, not the other, because we're friends. We play tennis with this one, we play golf with that one, whatever. And so, now I'm going to have two different brokers co-listing the property. Now, as you know, that creates additional issues when I get into the MLS, because the MLS is only going to allow me to have one. So, somebody's going to have to take the lead on this. Okay. So I'm at that point, if I'm going to have another broker, then I'm going to use the ABA form. And again, I want to caution you, because I've had lawsuits on this where people thought they were inviting in other people to participate in something, when in fact all they really did was give legal advice, and there was no intention to have a co-listing. So the second broker wasn't going to sign anything. Okay. All right. So let's take a look at that. Let's take a look and see what that form looks like. So we had our additional signature addendum. Now we're going to have our additional broker acknowledgement form, which says, guess what? We have another broker. We have two brokers that are going to co-list this property. And let's take a look and see what that looks like. Okay. So it's my ABA. Make sure I'm using the current version. It hasn't been revised because there's really not much use to it, but maybe the listing agreement, maybe the purchase agreement. Usually we see it in the listing agreement. Okay. So again, here's my recitals. Here's all the parties, all that kind of stuff. Let's go ahead and scroll down and mouse. So we're going to take a look at the listing agreement. And so what does that say? Co-listing brokers. So again, broker number one, Torrey Pacific, whatever. Broker number two, Burke, whatever. Co-listing brokers under the listing agreement identified above and agree to share responsibility, liability, and compensation for the representation of seller landlord as follows. So here's what our deal is going to look like. We have to tell the seller what that deal is going to look like, and that's part of where we start getting into trouble. So so that's what that does. Or it's on the terms of the attached agreement. Okay, you can do that too. Okay, what about my purchase agreement? So this is my listing agreement. Now let's talk about my purchase agreement. So check only one. So I've only got either A, or this is an or statement, or B. So either multiple brokers representing the seller, okay, or in the listing agreement, or multiple brokers representing the buyer in the offer. Okay, so again, check with your broker before you do that. Sometimes I hear people say, well, I didn't have any choice, I had to do it. Yeah, I know, but you had to also check with your broker to make sure it was okay with your broker. So please don't do things without your broker's advice. Okay. Again, they got a little bit more going on here, including little things like called E&O insurance, to make sure that we're hopefully doing things the right way. Okay. So, and then finally, let me scroll this down a little bit. I'm going to talk about number 3. We're doing good. I can't believe it. Oh man, where does it go? Activity under which the license of broker 1 and 2 will be conducted by multiple associates, partners, or teams, as indicated on the attached. And this is my additional agent acknowledgement form. So usually the agent acknowledgement form is done within the brokerage. So if I've got a team or 2 partners in the firm, that's where I'm going to be using that. So if I'm going to have additional, people within one firm do it, then that's when we're going to use my AAA form. Okay. So again, by signing below, wherever the name broker 1 or 2 appears, it appears everywhere as a representative for the buyer or the seller specified above, all that legal stuff. And again, you'll probably you're like me, you'll go 40 years and never see it. So, we just, I don't know that I've ever seen anybody do it. I'm sure they do. I'm sure they do it the way they're not supposed to do it. I don't know. It just, I usually don't get it until there's a problem. Okay. So here's broker number 1, here's broker number 2. Then we've got our seller or landlord, and then we got our buyer or tenant. Okay. Everybody good with that? All right. That is my additional broker form. And let me just make sure I don't have any questions. Oops, I do. Otherwise, each time I send a DocuSign, I have to enter the representative's info and email. very time consuming since it doesn't auto-populate. No, you're right, Nancy. You're right. It does not auto-populate. And even if you put it on the additional signature addendum, it still doesn't auto-populate. So, you know, it's just a form for you so you can contractually bind these people to it, but it doesn't auto-populate anywhere because our forms are designed for two. And it's like, when we get away from that, I mean, we need to get into where we have a little bit more flexibility. And so there's a lot going on right now. You know, I'm on the Lone Wolf Advisory Board, and I wouldn't be surprised. There's some big changes going on, you know, because we made a deal with NAR. NAR ended up selling the interest to Lone Wolf. Lone Wolf's a Canadian company. You know, I don't know. I'm on their customer advisory board, but I'm not sure how much impact I have. And I worry a little bit about where it's going. So, anyway, that being said, let me take us back to our form. Whoops, as a matter of fact, I think we've covered everything. Okay, so that is pretty much everything. Yep, we've covered all that already. So now we've covered that is the entire listing agreement. Does anybody have any questions about any of that? Because I want to make sure that we're covered. Y'all were asking really good questions today. I just wanted to make sure I didn't have any that I didn't follow up on. Yes, and Nancy, I don't know what to tell you, but so anyway, your last comment was a good one, and that is, otherwise I've got to enter the representative's info and email each time, but I would put it in number 1 and number 2. Use it. It's available to you. You have 2 spaces. Don't think about it as the seller, but think about it as I have 2 spaces that will automatically populate things, and that's what I would do. So any questions about any of that? No, that's a lot, but we covered a lot of stuff. Let me double check it really fast here. Okay, all right, well, seeing none, I want to thank you all for coming here today, and I look forward tomorrow at 10 o'clock. We will be doing Home Snap, and I apologize in advance. It will be a recording. I'm going to have to actually tape it tonight. I'm going to be on an airplane tomorrow when that class starts. And I know that they're not going to want me doing the webinar while I'm on the plane, and I can never count on internet. And then in the afternoon, of course, we'll have the RPA. We'll be doing paragraphs number 15 through 18, I think, and we'll be moving forward on that. So thank you all for being here today. I very much appreciate your time, and I look forward to seeing you, hypothetically seeing you tomorrow. Thank you for now. Take care.